Hello everyone and welcome to today's webinar. My name is Emma Pulkkinen and today my colleagues Katya Pasilla and Riku Kettunen and I will be talking about the legislative change regarding nominee-registered shares and specifically what is actually going to change and when. Before we start the webinar, I just want to remind you that the webinar will be made available on YouTube afterwards, and we will be sending all of you the materials, including a questions and answer documents afterwards. And we won't be taking any questions today live, but our chat people will be taking in questions and answering them as we go. But let's get started. First of all, our agenda for today is that I will tell you a little bit about the legislative change in a nutshell. So just to give you the main points about what is going to change. And then afterwards, Katya will come and tell you more about the implementation of the TRACE model in Finland. And we will go step by step what is actually going to change. So this will be the majority of the presentation today. Then we have Riku Kettunen telling us about TRACE reporting in practice, so the more technical side of the reporting. And then I will come back to tell you a little bit about the refunds of tax at source in the future, as well as how you can keep informed and how to get involved in all of the changes that are about to come. But yes, let's go into the main event, so the legislative change in a nutshell. I want to emphasize in the beginning that this is concerning nominee-registered shares, so shares that are in nominee accounts. And in Finnish, this would be hallintarekisteröidyt osakkeet. Now, one of the bigger changes that I know many of you have been concerned about is the abolishment of the foreign custodian register and the simplified procedure that goes along with it. However, I want to stress that this will be replaced by the Register of Authorized Intermediaries, and tax treaty benefits can still be provided at source. Basically, just the procedure is going to be a bit different. And then our annual information returns will be given using the TRACE XML schema. So our current annual information returns will become TRACE reports. And the default tax at source rate for unidentified beneficiaries will be 35%. I will go into more detail later on in the presentation what the rates will be under the new regime. So here I want to kind of visually represent what's going to change. So in the center we have nominee registered shares, as this is what the change will focus on. So our situation right now is that we have the custodian register, the related simplified procedure, which allows you to give tax treaty benefits at source, and you give annual information returns also after the year payment. So what's going to change? The custodian register will be abolished, but, as I already said, it will be replaced by the Register of Authorized Intermediaries. The simplified procedure will also be abolished, but tax treaty benefits will still be available at source. Then our annual information returns will become TRACE reports, which we will also go into more detail later on in the presentation. There have already been some questions regarding the time frame of the change, and now I'd like to go through kind of step by step what is going to change. So in the legal time frame, the first thing that will be applied is the 50% withholding rate for unknown Finnish residents. This will already be applicable next year, so starting from January 1st, 2020. Then the registration to the Register of Authorized Intermediaries will start in July 2020, so 6 months before the legislative change sets into force. And then on January 1st, 2021, the new tax at source rules become applicable to dividends paid in 2021. And then the related first TRACE reports will be given by the end of January 2022. Now, what does this mean in practice? What are we doing right now already? So already by the end of this year, you can start expecting a decision on the investor self-declaration procedure and related guidance. Then we will be publishing the technical reporting schema and also detailed guidance regarding the registration and responsibilities of an authorized intermediary. Then by the end of 2020 or the beginning of 2021, we will be publishing the Register of Authorized Intermediaries on tax.fi, and it will become public, so to say. And we've now estimated that the technical testing of the TRACE schema will be available for our IT developers in spring 2021. But we will keep you updated on how we progress, and we look forward to your comments as well, which I will also go into more detail later on. Now, as promised, I promised to tell you the withholding rates before and after the legal change. So in our current legislation, we have a 20% rate if the beneficiary is a corporate entity, 30% for individuals, and then 30% if it is unclear if the beneficiary is a corporate entity or an individual. Now, as many of you know, in practice, this is often the rate that is applied to nominee-registered shares, as at the time of payment, the information on the beneficiary is unavailable. However, in the current system, we do have the tax treaty rates that can be applied at source. Now, what's actually going to change? So, as I have stated on the presentation, the same statutory rates for identified corporate entities and individuals will remain the same. However, there is going to be a slight difference between those that are known or unclear versus those that are unidentified. So, the 30% rate is for beneficiaries which are known, but it is unclear what rate should be applied. So, for example, you're not sure if the entity is a corporate entity, whether the beneficiary is entitled to tax treaty benefits. So, for example, a flow-through entity investment fund, should it be taxed at the level of the investment funds or the final investor? So, these sort of situations, you would be taking 30%. But then we also have the 35%. Now, this is for situations when there is no information on the beneficiary available. So you do not know who the beneficiary is. And now for the contested 50% withholding tax, which I know it has caused some confusion for some of you. So this tax is for nominee-registered Finnish residents only, so whose information is unavailable. So this is the one that I was talking about that will be applicable already next year. In practice, this is situations where you know that the beneficiary is a Finnish resident, but the Finnish resident has told you that they do not want their information passed on to the Finnish tax administration. And as before, tax treaty rates can be applied at source. How that will happen, we will go into a bit more detail later on. So what happens with the withholding? The issuer, i.e. the paying company, is still the withholding agent, as in the current system. So the issuer is responsible for withholding. However, there are two scenarios. So if there is an authorized intermediary in the chain, the issuer can rely on pooled information provided by the authorized intermediary when withholding. If there isn't an authorized intermediary in the chain, the issuer has the sole responsibility and tax liability and has to collect the beneficial owner information before withholding. However, I would like to stress that even in the first example, where there is an authorized intermediary chain, you can rely on pooled information at the time of payment. However, you will still need to provide the beneficiary information with the trace reports. What happens to quick refunds? So, just as before, the amount of tax withheld at source can be adjusted during the year of payment, as today. So instead, the annual information returns will become the trace reports, but they must be submitted by the end of January the following year. So, for example, if a dividend is paid in 2021, you would be giving in the trace reports by January 31st, 22. So, and this would include any quick refunds you've made, so any corrections. So things will be very similar. And now, before we go into the next section, I just want to stress again that the whole goal of TRACE is to provide treaty benefits at source. So we do not wish to go into a full refund model. We want to keep our treaty benefits at source. But I want to again stress that there will still be procedures for any cases that are open to interpretation. So for example, we will still have the tax at source card procedure. So with that tax card, you can then adjust the tax at source. Also, for any cases where you will be withholding 30 or 35%, the applicant can always go through the refund application procedure. So, for example, this is a big thing for EU law cases where you are, for example, applying for comparability between a Finnish and a foreign investment fund. That's all for me now. I will come back towards the end of the presentation, but now we will watch a little interview that my colleague Katya Pasilla did with Philip Curves from the OECD. Enjoy.
I'm honored to welcome OECD's Head of International Cooperation Unit, Mr. Philip Curves, who has been involved in developing the TRACE in the OECD. Welcome, Philip.
Thank you.
TRACE stands for Treaty Relief and Compliance Enhancement. Could you tell us a little bit about what TRACE actually is and why it was created?
Yes. Well, the TRACE project started almost 9 years ago now, and it is a project that relates to the procedures that investors need to follow to claim treaty benefits under the double taxation treaties. It has grown out of an awareness that the procedures that countries have in this area are not so efficient. There's an awareness that has grown both on the financial sector side and on the government side. The financial sector confronted with very many paper-based procedures, often refund procedures with long delays. And from the government perspective, there was also an awareness that in terms of compliance, the existing procedures did not offer a robustness that they expected. And that's why we worked on a project, the TRACE project, which delivers streamlined and standardized procedures for claiming treaty benefits under the OECD Model Convention.
So how was the TRACE created? Who was involved?
It was in a way a unique project in the sense that we don't do that very often at the OECD, but this was a truly joint project with representatives from the financial sector and governments. We often consult, of course, when we do projects, but here there were two equal partners in the project. So that made sure that we had also people from the financial sector, from the back offices, who knew the back offices in this project. It was very important to make sure that what we developed works in practice.
That's true. Yeah, that's true. So, what benefits does TRACE offer for participating stakeholders, such as intermediaries acting as authorized intermediaries?
I think for the intermediaries, the authorized intermediaries, there are a number of advantages. Probably the main advantages is that they can work with procedures that are adapted to the way they work, so they can get rid of the archaic paper-based procedures. Not to be underestimated as well is that it allows them to claim treaty benefits without having to reveal customer information with upstream intermediaries, which are often competitors at the same time. And then also, if more countries start adopting TRACE, they benefit from standardization. So currently, a problem is that each country has its own procedures, and that goes with a cost on its own, and that can be eliminated if we apply the same procedure in all countries.
Great. So what about investors? What benefits does TRACE offer for investor?
I think for investors, the obvious benefit is that if you look at the situation today, and particularly with small investors, they just don't get the treaty benefits to which they are entitled because the procedures are too onerous for them to comply with. And also in comparison with existing procedures in a number of countries, one of the benefits is that they get the treaty benefits at the moment of the dividend payment. They don't
Yeah.
have to wait for years
Yeah.
to get their money.
So, how do you see the role of early adopters, such as Finland?
Yes, well, Finland is the first adopter of the TRACE system, and I think this gives Finland a very unique opportunity to continue working with the OECD and other countries in fine-tuning the system based on first experience. I mean, at the OECD, we always want to have an after-sales service, so we are still open to also learn from things that might need to be slightly amended based on the first experience.
Yeah.
And I think if you are the first country to implement, you are in a unique position to tailor it a bit to your needs.
Yeah. During the legislative process, there were lots of concerns in Finland that Finland is such a small country, there are no other countries that has adopted TRACE. What would you say to the global intermediaries that are now wondering whether they should register as authorized intermediaries in Finland?
I personally don't share that concern so much. And of course, every intermediary financial institution needs to make its own assessment, but this is not the first time that a smaller market adopts a system like TRACE. We have Ireland, they have a QI system. It's a relatively small market as well. And from what I know, more than 90% of the treaty benefits are claimed through their QI system. So it's not because you are a smaller market that I think custodians are not interested. And personally, I think if you become an authorized intermediary, you will be in a position to offer a better service to your customer, which puts you in a competitive advantage compared to the other intermediaries. So I would not be so concerned about lack of take-up based on the smaller market size of Finland.
Okay. How you see the future of TRACE?
Well, the future we'll have to see, but I think it's a very positive. Somebody had to take the first step, and Finland has now taken the first step. I think that will make it much more easy for others to follow, because what I often heard is from countries is we are interested, but we don't want to be the first one to do so. So I hope this will get the ball rolling now.
Okay. Thank you for the interview, and thank you for taking the time to visit us in Helsinki.
You're
Thank
welcome.
you, Philip. Hello everybody. My name is Katya Pasilla and I work as a senior advisor here at the Finnish Tax Administration. I was actually very excited to hear that there's so many of you hearing us today. So welcome to hear about the Finnish TRACE. Before I get started, I would like to emphasize that we are very committed to offer you all the guidance and all the help you need in order to evaluate whether you want to start acting as authorized intermediary, and overall that you know what the new rules contain. I would also like to say that our guidance is as good as we know how to do it. So we don't want to guess what you need, we want to know what you need. So we very much appreciate all the questions that you send to us, and we hope that you keep sending those to us so that we can take those into consideration when we are drafting the guidance. The legislation passed the Parliament quite recently, so we are currently in the phase that we are drafting the guidance. So give us some time, but just once more I want to emphasize that we are committed to offer you all the guidance needed, and also in English. So I hope that I eased your concerns a bit. I know that many of you is aware that something is changing, but you don't exactly know what and when and what is actually going to happen. So I'm hoping that today's presentation will ease your concerns at least a little bit. But let's go further. So, implementation of OECD's TRACE model. As many of you probably know, there isn't any countries that have implemented the TRACE. So Finland will be the first one. But what we are hoping is that we won't be the only one, and other countries will join us. The TRACE in Finland. The legislation sets grounds for the new system. It contains detailed rules for the liability and responsibilities of authorized intermediaries. But a lot was left for tax administration to decide with secondary legislation, which is tax administration's decisions and guidelines. For example, what we are going to give you guidance, more detailed guidance about is the details of the investor self-declaration procedure and the tax reporting schema. However, it is very clearly stated in the legislation that we need to take the trace into consideration in everything we do. So we need to follow the trace. So if you are familiar with the trace, you already know what kind of system we are going to create. The trace implementation package lays the foundation to the implementation. In the Finnish context, this will include a register for authorized intermediaries, and there's the rules on the extent of authorized intermediaries' liability for any under withholding of tax. Also, what is very important in the TRACE IP is the rules and procedures for recognizing and identifying the beneficial owners. And this includes the investor self-declaration procedure, which we will adopt quite as it is in the TRACE implementation package. The reporting will be done with the TRACE XML schema, but what we don't have is the independent review. So for those of you who know TRACE, you know that it includes independent review. We don't have that as a mandatory procedure. You can use an independent reviewer if you want to, but that is completely optional. If you decide not to use the independent reviewer, this will just mean that all the material related to the investor self-declaration procedure will be audited if necessary by us. I'm going to tell you a little bit more about that later on. So how to register to the Register of Authorized Intermediaries? The registration is available starting from 1st of July 2020, so in July next year. And what I want to emphasize is that in Finland, you don't do any kind of contract with us. So you become an authorized intermediary by registering to the Register of Authorized Intermediaries. This is also an option that you can find from a TRACE implementation package. So this follows the TRACE registration version of the authorized intermediaries. The registration comes into force and the register is published on the 1st of January 2021 when we start applying the new rules. We will publish a specific form and instructions on how to register somewhere in the spring 2020. Then the eligibility to register. So who can register? Who can act as an authorized intermediary? Well, first, you need to have the right to operate custodian activity under Finnish legislation or comparable legislation of another country. You need to have a permit issued by a competent supervisory authority for safekeeping of financial instruments. You need to be supervised by that supervisory authority. The intermediary needs to be resident in the European Union or in a country that Finland has a signed tax treaty with. Also, the intermediary needs to be a financial institution obliged to report under either CRS, DAC2 or FATCA. And you also need to be obligated to follow anti-money laundering and know your customer rules. So that is basically it. And I would say that majority of you listening today already know that you have fulfilled these criteria. So I guess Emma already mentioned that we will publish the register. And many of you might be concerned what kind of information becomes public. Well, the register will be available online at tax.fi, so our webpage. And the reason why it's public is that because the system requires that all the acting parties needs to check whether the other intermediary is registered or not. So that is why we need to have the information public. But the legislation regulates what information is publicly available, and this is the only information that we can publish. So this is the list and nothing else. So it's going to be the name of the intermediary, or the name of the authorized intermediary, the Finnish business ID issued by us to the authorized intermediary, and its corresponding ID code issued in the foreign country. So the tax ID or identification ID that you use in your residency country. Country of residence, address, and the period of validity of the registration. You can also deregister from the register. So it's not like if you register, you need to be registered forever. You can request to be deregistered from the register. And we can also deregister you if the registration requirements are no longer met, or if the administrative errors or other minor errors have repeatedly led to taxes being withheld incorrectly, or other information being reported incorrectly. If the intermediary doesn't comply with the provisions and obligations set by the law and doesn't pay the taxes imposed, then we will also deregister that intermediary from the register. So the role of an authorized intermediary. I already mentioned that the status of an authorized intermediary is received through registration to the tax administration's Register of Authorised Intermediaries. So no contracts. You just apply for registration, and if we approve the registration, then you are registered. And then the role is the same role as set in the TRACE implementation package. And the authorized intermediary has the responsibility to identify the beneficial owner, give the TRACE report on annual basis, and provide further information regarding the dividends paid through that authorized intermediary when separately requested by us. So I can give you an example. Let's say one of your clients is applying for a refund, and there's something that we need to clarify. They, for example, provide us with the dividend voucher, so then we could ask from you whether the voucher is correct, or whether you have provided that voucher to that beneficiary applying for a refund. That's just an example what kind of further information we might ask from the authorized intermediary. Also, the issuer has the right to receive information from the authorized intermediary, what kind of information that they need in order to meet their tax obligations as a withholding agent. So only the issuer has the right in addition to the tax administration, and the issuer has limited rights. So it's limited to the information they need in order to meet their tax obligations. So no other intermediary has right to receive the information that you provide to us. I know the next issue is something that many of you are concerned about. I know you have heard rumors that we are going to make the intermediaries liable, and that is true. The authorized intermediary does have tax liability regulated by the law, and the authorized intermediary has tax liability for beneficial owners which it has reported with lower tax rates. So if you report an beneficial owner with a treaty rate, you have the tax liability for that beneficial owner. But the AI isn't held liable if AI shows that the tax wasn't withheld with too low rate due to the AI's neglect. I'm going to explain this to you with an example a bit later. And then another question that we have received a lot is what happens if there's several authorized intermediaries in the chain? Who is actually liable? So it is very important to remember that the AI that pays the dividends to another authorized intermediary isn't held liable after that AI reports that the dividend was paid to another AI. This is also something that I'm going to explain to you with more detailed with an example. So here's the example for a situation when we would hold the authorized intermediary liable. So let's imagine that the AIB has a customer C. AIB has received an investor self-declaration from customer C stating that C is resident in France. AIB doesn't validate the investor self-declaration and doesn't compare it to the know your customer and anti-money laundering information that they have from the, concerning the customer C. There are signs in that documentation that customer C is actually or might be resident in Germany, but the AIB applies the tax treaty with France anyway. In that case, if it's later found out that the customer C is actually resident in Germany, we would hold the AIB liable for the under withholding, and the reason for that would be that they haven't done the validation to the investor self-declaration as required by the procedure set in the TRACE implementation package. I'm going to show you another example explaining when the AI isn't liable. So let's take the same AIB. Now they have a customer D. AIB has this time followed the investor self-declaration procedure, and they have validated the documentation as required. There isn't any sign that in the AIB's records that would indicate the documentation is misleading or false. AIB didn't know and could not have known that customer D had misled it. AIB isn't held liable for under withholding, and in this scenario, we would collect the tax from the beneficial owner. So let's say that there is, like you can see the pictures here, the customer D has conducted some kind of tax evasion scheme completely outside of the AIB's system and knowledge, and it has been that kind of scheme that the AIB could not have known about it. So in this case, we wouldn't hold the AIB liable because they have done everything they can and they have followed the procedure, and the customer D has misled them. So it's not completely strict liability. That is very important to remember. And I understand that now you have a million questions in mind. Please send those to us. We will give you very detailed guidance on this matter because we understand that this is one of the key issues for you in order to decide whether you want to act as authorized intermediary or not. So few words about the investor self-declaration procedure. Well, the most important one is that in the new system, the investor self-declaration is considered a sufficient documentation for granting the treaty relief. So there is no need to have the certificate of tax residence for every client. So you can rely on the investor self-declaration, provided that it's backed up with sufficient documentation and that you validate the document. And its content cannot be contradictory to the other information that you have about that client. So you need to conduct a reliability test that is actually described in the TRACE implementation package. So we are going to follow that procedure set in the TRACE implementation package. You can probably see at least a little bit of that picture. That is just an extract from the TRACE implementation package. It's an example for investor self-declaration for entities. There are also a separate one for individuals. So we are going to use these as a model, so you can have a look at these examples in the TRACE implementation package to see what kind of investor self-declaration you need to collect and what kind of other what kind of validation you need to do to that documentation. I'm going to give you one example. I know there's a lot of text in the slide, but I'm going to explain it to you. So investor C has given a sufficient investor self-declaration to the AIB, stating that C is resident in Germany. When C gave that investor self-declaration, all indication in AIB's Know Your Customer and anti-money laundering documentation regarding C pointed towards Germany. AIB can now grant the treaty benefits based on tax treaty between Finland and Germany to C. So that's all done. So you can apply the tax treaty. Then a year later, C informs AIB about new postal address that is in France. The postal address in France is in contradiction with the information given in the investor self-declaration, which stated that the customer is resident in Germany. So now when they have this kind of sign that points towards another country, in this case France, now the AIB can apply either the tax treaty with Germany nor the tax treaty with France before B receives a sufficient explanation on the C's tax residency status and an updated investor self-declaration. So when you think about the validation procedure, you also need to do follow-ups. So if you have some kind of sign that points towards another country, you need to react to that sign. But this is, once again, one of these issues that we are going to give you more detailed guidance. And if you have any practical issues or any kind of situations in mind that you wonder, please send those to us. We really much appreciate. Then I'm going to show you that example that I promised. This is a very simplified example of a dividend payment chain. I, of course, understand that in real life there's a rarely situation where the whole dividend batch is paid with the same amount through the whole chain. But this is just for so that I can go this with a simplified example. So here we have this option where everybody has registered. So all the intermediaries in the chain have registered as authorized intermediaries. Here we have X as the issuer, so the Finnish company that pays out the dividend. X is the withholding agent. Now when the X has checked that, okay, there is an authorized intermediary in the chain, X can rely on pooled information at the time of the payment, meaning that the only thing that you need to provide through the chain is the breakdown by country. So the pooled info, how much dividend with the UK rate, how much dividend with the Germany rate, how much dividend with the French rate, etc., etc., etc. So the similar system that you conduct now when the dividend is paid. So when there is this authorized intermediary in the chain, X can rely on pooled info and the country breakdown is enough at the time of the dividend payment. Then the due date for trace reports is the end of January next year. So at that time, all the authorized intermediaries need to report towards us. But what is very important to remember is that not all the authorized intermediaries give the same information. They actually give different kind of reports. In this scenario, AIA, which is also acting as account operator in the CSD, informs us in the trace report that they paid the dividend to authorized intermediary B. So they give us this so-called other AI information, and that's it. So they provide us with the information about AIB and the total amount that they paid to the AIB, and that's it. And once they have done that, they are no longer liable because they have shown us that, okay, we actually paid the dividend to another authorized intermediary. Then the same goes with the AIB. They give us information about the AIC that, okay, we paid the dividend to another AI. And then they are done with their responsibility. Then there comes AIC, which is the closest intermediary when you think closest to the investor. So the investor is actually a client of authorized intermediary C. Now it is the AIC who gives us the information about the beneficial owner. So they will provide us with a lengthier trace report containing information about the beneficial owner and the dividend that they received and the tax rates, etc. And in this scenario, the AIC would have the ultimate tax liability for the information concerning beneficial owner C. Naturally provided with the fact that there hasn't been any kind of misleading or anything like that, but in principle, AIC is responsible and liable for the information that they have provided about beneficial owner C. There is also this kind of like secondary liability that still lies with the issuer, meaning that if the AIC doesn't pay, then we could collect the tax from the issuer. But the purpose of the law is that the authorized intermediary has the primary tax liability. And I know this might sound confusing, especially if you aren't familiar with the TRACE technical schema. But the schema actually supports this kind of reporting. So there are different elements for reporting purposes, depending on what role you play in the chain. So when you will see the schema and the guidance related to that, you will see that it's actually, it starts to make sense. And the benefit for us is that now we will have more visibility towards the chain, which will especially help the refund process that Emma will later tell you more about. And what is also very important with TRACE, because I know what kind of complaints we have received regarding the current system, because in the current system, you have had to report the beneficial owners if you go below 15%. And the problem has been that you have had to provide the privileged customer data to probably you're one of the biggest competitors, and you have to provide that information through a chain that can be a very long chain with many intermediaries. And with the TRACE system, you don't have to do that. You can just report the privileged customer data to us and just put the pooled info to the chain. So the only one who will know your customers are us. And Riku Kettunen is going to tell you more about the security aspect of reporting later on. Okay, so let's continue. So then I know that now you're wondering that, okay, it sounds it kind of makes sense if everybody has registered, but what happens if everybody doesn't register? We do understand that that's the reality, that there might be intermediaries that either don't want to register or they don't find it a feasible solution for them to register. But that isn't the problem, because then we have the role of contractual intermediary. And the new system recognizes the role of a contractual intermediary, which is called CI, as stated in the TRACE implementation package. CI is an intermediary that AI has a contract with. And in this scenario, the AI accepts reporting responsibilities and tax liability for the information provided by the CI. So CIs don't register they don't also do any kind of contracts with us. So CI is a kind of like a role that don't have any kind of relationship with us. And of course, it's up to the business to decide how you will handle the tax liability in this situation, whether you are going to make some kind of contractual arrangements. But from our perspective, the CI isn't liable, but the AI that reports information given by the contractual intermediary is responsible and tax liable for that information. I'm going to clarify this with the example. So the same scenario, but now the intermediary closest to the investor hasn't registered. So the CIC is acting as contractual intermediary. In this scenario, X is once again the issuer. Then we have the AIA acting as authorized intermediary and also account operator in the CSD. Then we have an AIB and then contractual intermediary C and then the beneficial owner. So in this scenario, AIA would once again report that we paid the dividend to another authorized intermediary B. But now, AIB and CIC has a contractual relationship with AIB. AIB has accepted the tax liability and responsibility for the information provided by CIC. So they have made a contract that, okay, we will carry this tax liability and responsibility. We will do the reporting and carry this tax liability. CIC might be such a small operator that they don't want to start doing the reporting, or there can be various situations. But the point is that in this scenario, AIB would be liable for the information about the beneficial owner C. But it doesn't mean that AIB is made liable for something that they are not ready to take. So this scenario can only happen if AIB accepts the liability. So in this scenario, AIB would report us with the information about CIC as top CI in the TRACE report, and also provide us with the beneficial owner information. If we would have any further questions, we would then address AIB. So what happens if there are several CIs in the chain? Once again, this is also a situation that the trace model and the trace schema takes under consideration. So this also follows the trace model. Now we have X once again as the issuer. We have once again AIA as an authorized intermediary and as an account operator. Then we have CID here in the middle. Then we have another AIB and then a CIC and then the beneficial owner. This situation is a bit more complicated, but recognized by the trace implementation package. So in this scenario, if you think about from the X perspective, X can once again rely on pooled info because they know there is an authorized intermediary in the chain. So it is enough that at the time of the dividend payment, there comes the country breakdown with the pooled information towards X. But then where it gets more interesting is what AIA needs to do. So the next one in the chain isn't registered, so there's a contractual intermediary D. So AIA is in principle responsible for everything that and all the information that CID provides. But what they need to do is to verify that there is another authorized intermediary in the chain. So if authorized intermediary A verifies there's AIB in the chain, so there is another authorized intermediary, then they can proceed with the pooled information, and they would just report the CID and the other authorized intermediary AIB to us with the trace report. So they would basically report and do the checks like CID wouldn't even exist. So this is also recognized by the trace model. I know that this might be more difficult in practice, but it doesn't. It isn't difficult from the reporting perspective and from the legal perspective, but I know this can have some kind of like a practical, it might not be so practical solution, but it's possible. And in this scenario, the situation for AIB is the same as previously. There's a CIC closest to the beneficial owner, which means that the AIB, which is now the closest intermediary when you think about it from the beneficial owner's perspective, is now ultimately liable for the information regarding beneficial owner C. So I know that we can do all kinds of scenarios, but actually all of those scenarios are recognized by the trace model and the reporting schema. But if you have any concerns or you have a specific situation in mind, I know people have asked what then if the account operator isn't registered? What happens then? Because in practical level, the account operator acts on behalf of the issuer. So even though issuer is the withholding agent, we all know that it's actually the account operator that actually acts on behalf of the issuer. So even that kind of scenario isn't an issue if the account operator verifies that there is another or there is an authorized intermediary in the chain. I probably made you even more confused, but you will receive this material afterwards and you can go through with the examples and send us the questions. Hopefully that will clarify the situation even more. So, few words about tax reporting in future and about the trace schema. The schema, when I first saw it, I was like, oh my, whoa, this looks a very complicated one. But that is mainly because the schema has been created to meet various needs and income types. And I don't know if you are aware, but the trace is actually the mother schema of all of these XML schemas done by OECD. So FATCA and CRS and DAC2 schemas were actually created on the basis of trace schema. So there is lots of similarities and the same technical setting. And since all of those qualified as authorized intermediary or even as contractual intermediary are in principle financial institutions based on these CRS or FATCA or DAC2. So the schema is well known, and the biggest benefit probably is that the information that you now collect for CRS about the account holders, it's pretty much the same elements that you need to collect from the beneficial owners for trace purposes. So most likely you are able to use the same technical solution that you use for CRS or FATCA. You are probably able to use it for trace as well. Of course, the information is different. The content is different because for CRS you collect the account holder information, and for trace the dividend beneficial owners. But I would imagine that that all of the information is collected from your customer database. So you are most likely able to use the same technical solution to quite large extent. So just to give you some kind of, to wrap it up about the benefits of trace, I know you saw the interview I made with Philip Curves from the OECD. Philip actually quite extensively already told you about the benefits, but just to give you like a conclusion. For authorized intermediaries, the benefit is most likely the procedure adapted to industry standards. So the reporting is done in XML format. The use of pooled information, which is going to make the practical dividend payments a lot more easier when you don't have to have the beneficial owner information at the time of the dividend payment. And also the direct reporting with tax officials, so there is no need to give your privileged customer information to your competitors. You can just provide it to us. The trace also have many benefits for investors. The biggest one, of course, is the treaty benefits at source. And even for those situations that the treaty benefits aren't available at source, or for some reason there's uncertainty about the correct tax rate, if you provide us with the beneficial owner's information anyway, the investor will receive a lot smoother refund process. Good example are the investment funds, where there can be unclear whether they are entitled to treaty benefits, but in Finland, a majority of investment funds actually seek the zero rate based on EU law, but that usually cannot be applied at source. So what is now the big issue is that when the investment fund is applying for a refund, we need to require a lot of information about the dividend payments or dividend voucher, etc., etc., etc. So we need to track the payment. But with the trace model, even if the maximum rate was withheld or 30% was withheld, if we have the information given by authorized intermediary that this investment fund was the one that received the dividend, it is going to make the refund process a lot more easier. Because then we are going to see that, okay, there is an authorized intermediary that gave us the statement that, okay, we paid the dividend to investment fund D, for example. Because the issue with the refund is, as you all know, are the refund frauds. And that is the reason why we need to detect the money when we are processing refund claims. And from that perspective, the trace is going to help the refund process quite a bit. There's also a huge benefit for tax administrations, because it's going to give us a better ability to ensure proper compliance with tax obligations. And like I also already said, it's going to give us a better view on the chain, which is going to make our processes easier. And I guess the biggest benefit is that the more countries adopt the trace model, the greater benefits for all stakeholders. So we are hoping that even though we are the first one, we won't be the only one for long. Then a few words about what happens if you don't want to adopt trace. Trace is actually an option in Finland. It's actually an option even in the trace implementation package. So the whole idea of the trace is that it's not completely mandatory. And it's not mandatory in Finland either. So you can opt out the system. In that scenario, the beneficiary information must be provided through the chain before dividend payment in order to provide the treaty benefits. So it's pretty much the same procedure that you now need to follow for dividends where you go under 15%, so 0 to 15 rates. And it also means that the issuer, which is the withholding agent, and in this scenario, the only one responsible for the tax, cannot rely on pooled information. The tax liability and responsibility lies with the issuer, which is the dividend distributing company. So the issuer can use the service provider, for example, custodian or the account operator, but the tax liability still lies with the issuer. And the annual information returns must still be provided, and they need to contain the beneficial owner information. So this is kind of like if you opt out the trace model, what you will lose is the possibility for pooled information and the possibility to report the beneficial owner information towards us. And also it's basically the same procedure that you now follow for the dividends paid under 15% rate, so 0 to 15% rates. That is basically the procedure that we'll have if you opt out trace model. So here's an example what it would look like with the same scenario. So here we have, once again, the X as the issuer, the account operator A, and then intermediaries. None of these have registered. So in this scenario, X cannot rely on pooled information, and X is responsible and liable for the tax, and they have the responsibility to provide us with the beneficial owner information. So if you think about it from the intermediary C's perspective, the intermediary C needs to provide the privileged customer data about beneficial owner to the intermediary B, which will then pass it on to the intermediary A, which will then act on behalf of the issuer. So it is possible to opt out, but the benefits of the trace model are quite extensive, even though there is the tax liability, but the tax liability can be handled with the investor self-declaration procedure. This was all from me today. Like I said in the beginning, we are very committed to provide you with all the guidance needed. And I already said it, but I'm going to say it again. We don't want to guess your needs. We want to know your needs. So please let us know what kind of guidance you need, what kind of practical situations you have in mind that you need clarification to. And we will do our best offering you all the guidance in English. Next, I'm going to invite Riku Kettunen here to tell you more about trace reporting in practice. Riku is actually an ICT specialist who will tell you about, for example, the security of reporting. So thank you, and please welcome Riku.
Hello everyone, I'm Riku Kettunen from Tax Administration's Development and IT unit, and I'm here to tell you about a little bit about technical points of view, how to make the trace reporting in practice. Today we are not going to very deep in technical ways. We are talking about a little bit how the data is collected to us, how you can fill in, what kind of methods there are to provide those data and to be sending in, and then a little bit of about the security issues that, of course, are really the main point, I would say, in my presentation. How the data is collected. Like told before, we are using the OECD trace schema for the initial reporting. in the corrections, we are still a little bit thinking that we might have this kind of a option, the deviation from the normal process. This is under discussion at the moment, and we will give our initial thoughts later on, and we will be giving you a chance to give your opinion about this one. When the declaration is received in our end, we of course we are doing the XML and business validation, and on that time there might be a contact point to you that if we found some errors on that step. Of course, there will be OECD technical guidance for trade schema itself, but also the Finnish tax administration will give a specific technical guidance about how to make the filing, and that will be presented to you later on. And I would say that we are going to give more technical details on that time. And also when we are giving out those information, we are really happy to answer any questions that you may have on that time. A bit about the channels that we are using. The declarations can be made only by electronical means using the Finnish Tax Administration ilmoitin.fi service. Of course, in that way, you have to have the file ready, the XML file ready. Filing itself needs that the filer needs to be identified, and there is two options. You can use it a web interface or web service. And we do have two environments also. Test environment and the production environment. And of course, in the test environment, you should never use the production data. That should be used only in the production environment. In both environments, we do also have a possibility that you can, before you fill out the file itself, you can check it out. That it is going through these initial validations. So that's one option that we are giving, that before the production data is filled in, you can go in, check out that the file is correct, and before you file it in. And also ilmoitin.fi provides you an archive to your already sent files. The identification to ilmoitin.fi is managed by a secure governmental-wide identification method. This ID can be granted for both Finnish and the foreign customers, and it's a strong authentication method in both cases. And during 2020, this identification of Finnish and foreign customers will happen via Suomi.fi identification and authorization. And for all of you from abroad, we are in a governmental-wide state now making this new system on place, so there will be more detail released later on about this new system during this year. And then about the security aspects. Of course, as the Finnish tax administration, while we are a governmental body, we are following all the national and EU legislation about the personal and data protection. As a IT level, we are making sure that all our systems are secured, they are monitored all the time. And for example, for ilmoitin.fi, where you give the information in, you give the declarations, it is a secure way, it's owned by tax administration, we are estimating its security on a regular basis, and we are updating it on security patches regular basis. While we are building our own systems, we are following all the governmental guidelines that are based on ISO systems. And our systems are regularly evaluated by ourselves, our security unit, but also when it comes for international data exchange by European Union and OECD and other parties. So we are not relying only on our own system evaluation. Furthermore, when it comes to the access to the actual data, it's always, the access is always limited to those officers that really need that information in their work. The user rights are handled with our own guidelines, and it's always the guideline goes that the supervisor is the one that applies that this person might need this access to the data. And these accesses are evaluated regularly. That is it still necessary that this person, this official, has a user rights for this data. In our systems, all the events are logged, and these logs are reviewed on a regular basis and checked out. And that's, I would say, our main goal, to keep the security in the highest possible level. That's all I have today. Thank you, and Emma will continue with you.
All right, I'm back to round us off for the webinar, and I'm going to tell you a little bit about what we have planned for refunds of tax at source. So what is involved with refund applications in TRACE? So alongside all of the mandatory changes that we have to do with the legal change, we will also be renewing our refund application procedure. And this will actually include a new digital application form for refunds, but we're also looking into the digitization of the tax at source card application. Now, our legislation basically states that we need to take the TRACE model into consideration in everything that we do. So, of course, we will also be taking it into consideration when developing the new refund application procedure. Now, the preliminary launch will actually already be next spring, hopefully, and we'll be keeping you informed about how we develop things and how you can also get involved in the developing process. Now, I want to stress that the goal of this whole restructuring and reprocessing is to smoothen the process itself. So this is especially for our future authorized intermediaries. So for example, we're looking into the possibility of bulk submission in XML format. And I think this will be especially for authorized intermediaries, as we will also be looking into what will be the documentation requirements for an authorized intermediary versus another agent, for example. So what's actually going to change? So as many of you know from the information requests that we send to you, a lot of our resources go into tracking the flow of the dividend payment, of which I have an example here. So often we only see the first global custodian. So in that case, we are always requesting you to tell us the entire chain. And you, as the applicant or the agent of the applicant, you often only are aware of the bank that paid the dividend directly to the applicant. So we understand that a lot of your resources also go into trying to find out what the full chain is. But now, with our new system, the trace reports, we will be better equipped to track the payment vis-a-vis what Katya was telling you about the flow of the payment and the trace reports before. So yeah, with the help of these trace reports on beneficial owners, the chain will become more visible and we will be needing less information from you. But as I said, I will get back to you on more details about what will change. We are looking into using the template of our current application form 6163E and of course making some modifications that are better for you. Now, just to end today's webinar, I want to remind you of how you can keep informed with what's about to come and also how you can get involved. So, as you know, we've already been publishing a newsletter for the financial sector where we have been telling about the legal change and what is involved. And recently we even published a newsletter with the specific theme of this legislative change. So if you haven't already, please subscribe to the newsletter. It's published in Finnish, Swedish, and English. So through that, we will be informing about how things progress. I also urge you to keep an eye on our tax.fi page, Financial Sector and Taxation. And again, all information there will be in Finnish, Swedish, and English. So there we have all the published news bulletins concerned with the legal change. We have the links to the webinar presentation material, to the YouTube presentation. And when we have the guidance that we were talking about before, it will also be published here. So we want a one-stop shop for you where you can find everything that you need. And of course, there will also be future webinars. The first, which has been confirmed now, is the webinar for our issuers, which will be in autumn 2019. And this will be in Finnish. However, we will be hosting future webinars for our other stakeholders and also in English. And now, how to get involved. So, of course, there will be an official hearing in writing, but this will be done only in Finnish and Swedish, as those are the official languages of Finland. However, as Katya was already saying, we are really looking forward to hearing your comments, your thoughts, your concerns, anything that comes to your mind from the financial sector more globally. And as an idea, we've now been talking about a regular Q&A Skype meeting, which will be open to everyone. And preliminarily, we have thought about this starting in autumn 2019. So we would be sending a link where you can all join and ask any questions you have on your mind. At the same time, we understand you may have questions that you want to ask privately, that you want to discuss without any other actors present. So we do also offer one-to-one meetings on demand, subject to availability of our calendars, of course. And these can also be organized via Skype or physically here in Helsinki at our Vallila office, whichever suits you better. And yeah, just let us know if you want to get involved. So we have a group email, financialsector@vero.fi, where we hope to get all of your questions, concerns, interest in getting involved. So for example, if you're interested in testing the trace schema, or as I said earlier, if you're interested in co-developing the new refund application with us, we'd be really glad to hear that. So just get to the email address and we'll get back to you. So that's all for today. I want to again remind you that the presentation material, the YouTube presentation itself, and a Q&A document with all the answers to your questions that you've either sent us beforehand or published in the chat. We will get back to you with a full Q&A document answering all your questions. And as I already said, please feel free to contact us at financialsector@vero.fi. The YouTube presentation will be made available tomorrow. I thank you, Katya and Riku, thank you, and please don't hesitate to contact us for anything. Thank you.